always get to talk more about the process part of this, but, so I'm going to start with a quote about meetings, and this was a recommendation from Madame Bellamy, who was part of the inquiry into the Toronto computer leasing issue. She said that council should take steps to enhance the openness of council meetings. Another one about council meetings from the Supreme Court of Canada said about council meetings and open meetings, stating that they are intended to increase public confidence in the integrity of local government by ensuring the open and transparent exercise of municipal power. So that's how we start. The overarching principle of municipal meetings is that they are open. Meetings are just another way for the municipality to engage the public in their decision-making process. They are what allow council to do their important job of providing government, and they are what allow them to govern. You don't get to govern if you don't meet. And they are key to accountability. You're seen to be governed, and you're governing in an impartial way, so that accountability really can't happen without transparency. When we define a meeting, we do have a definition in the Municipal Act. What it says is that a meeting is any regular, special, or other meeting of council of a local board or of a committee of either of them. Maybe pretty broad. So we can look to the common law courts to provide a little more narrowing of that, and they have addressed the purpose or the intent of those persons who are getting together and have determined it to be any gathering to which all members are invited to attend or do attend to discuss matters within their jurisdiction. Yet another way to say that, it's a meeting if the matter under consideration is normally the subject of council business and all members of the council are invited to attend or they do attend. The legislation, of course, is the authoritative text. Case law is what you can use to help assist in your understanding of what a meeting is. There are certainly other sources of information you can look to as well. The Ontario Ombudsman has provided some definition of that as part of his meeting investigation into Sudbury City Council. And he looked at it and said that legal definition of a meeting is a meeting under the Act should be interpreted as follows. Members of council or a committee must come together for the purpose of exercising the power or authority of the council or the committee, or for the purpose of doing the groundwork necessary to exercise that power or authority. So that helps define what we're talking about when we're talking about a council meeting. I'm going to speak to some of the ground rules about what the legislation says in terms of municipal meetings. First of all, just being a reminder, whether it's in the council chambers or not, when council members are together and they're discussing municipal business, you can see that that would be considered a meeting. All meetings are to be open to the public unless council chooses to close the meeting, and I emphasize the choosing because there's only one instance in the legislation where it is mandatory to close a meeting, and that is if a council is considering a request under the Municipal Freedom of Information and Protection of Privacy Act. So all votes, with very few exceptions, those are to happen in open session. A quorum is required to conduct the business of council at the meetings. There must be a record or minutes of every meeting, both open and closed, which means that since the clerk is the one who's taking the minutes, the clerk must be present at the meeting or someone acting as the clerk. So you've got someone acting as staff or the clerk at each meeting in order to take minutes. So if a council were to discuss municipal business and the clerk isn't present, that isn't what means that it isn't a meeting. That just means that the council may have contributed to aspects of the legislation. Procedure bylaws are another part of the ground rules that the Municipal Act sets out for municipal meetings. There what describes how your meetings are to be conducted. It is a mandatory bylaw, but it's the municipality that describes the contents, and it's appropriate to the municipality. It must provide for public notice of meetings, for all meetings, and that should be consistent with your own notice policy. It's also a really valuable tool for transparency and accountability. It's probably one of your most visible indications of your commitment to citizen engagement because it's what describes how citizens can be involved in your meetings. It really should be a tool to facilitate and not frustrate the decision-making, and should be reviewed regularly, and I understand that's something you're considering currently. One particular case that I came across that might be of interest to the members, this is a case that happened, was decided on recently, and it's dealing with that issue of balancing freedom of speech and the need for a calm atmosphere for deliberation in council meetings. This was back 2011 in July. The justice ruled on the defendant's appeal against a conviction relating to a charge under the Trespass Property Act. The judge considered the municipality's procedural bylaw, which stated, "No person shall speak disrespectfully of any person, use improper language, or speak on non-approved subjects, or disobey the rules." And in summary, the judge said that the bylaw is a legislative statement of the council's inherent jurisdiction to control discussions during its meetings. The judge ruled, "This restriction on the public's constitutional right to be present at public hearings is a proper restriction on the general right of assembly and acknowledges a public body's inherent jurisdiction to control its own process in order to create an atmosphere of calm deliberation." And the justice went on to conclude, Section 1 of the Charter recognizes the need for society to restrict what otherwise would be a fairly free-ranging individual freedom in certain acceptable and reasonable circumstances, and such is the case with the freedom of assembly and expression at the public meetings. The Municipal Act, so I have mentioned this a number of times, requires notice for all meetings, both open and closed. And when we speak about notice, we're talking about public notice, not notice just to staff and to council, but notice to the public. A notice policy is a mandatory policy, but again, the municipality describes the contents. As long as it includes the circumstances in which the municipality gives notice, the form, the manner, and the times notice will be given. Now on to closed meetings. These are the exceptions to the open meeting rule. So some of those that I'll just touch on, security of municipal property being a reasonable reason for a council to go into a closed session. That might be something like a discussion about a security system on one of the facilities that within the municipality. You can understand why it wouldn't be appropriate to discuss the security features of a new alarm system in an open meeting. So that might be something you need and want to go into a closed meeting for. So that's the list that's included in the Municipal Act. There is also education and training. That's a relatively new exception to the open meeting rules. There are a number of conditions associated with it, though. A meeting may be closed if it is held for the purpose of educating or training the members, so long as no member discusses or otherwise deals with any matter during a closed meeting in any way that materially advances the business or decision-making of the council, local board, or the committee, as the case may be. A matter can also be closed under the authority of a statute other than the Municipal Act if it's referenced there. And as I discussed as well, some freedom of information requests require a meeting to be closed. In terms of the procedure, again, public notice required for all meetings, the method and content to be determined by the council. Clarifies in the Act that there needs to be a record of all meetings. That's mandatory. Education and training minutes are public, even if the meeting is closed, even though all other closed meeting minutes are not open or public. So before going into a closed council session, council must pass a resolution that states that they're going into a closed session and the general nature of the matter to be discussed. And now they must also include information about the subject matter if they're going into a closed session for the education and training purposes. It is important to note that it is council that closes the meeting. It's not staff's prerogative. It's not a lawyer's prerogative. It's not up to the public. It's up to the council. Those other people can provide some advice in those cases, but it is up to council. There are to be no votes as well. I'll touch on that at closed meetings, except to give instruction on the matter to staff or for procedural matters. In terms of the investigative process, this is a relatively new process in the legislation. If someone thinks that the municipality or a local board has not complied with the legislation or the municipality's own procedure bylaw as it relates to closed meeting rules, then they may request an investigation. And that's been since the beginning of 2008. And it's any person. It doesn't necessarily have to be a citizen of that municipality. Any person is able to request that an investigation be undertaken respecting whether or not a municipality, a local board, or a committee of either of them has complied with the closed meeting rules. And as I've touched on, municipalities can appoint their own investigator, and if they do not, it is the provincial ombudsman that serves as the investigator for this purpose of the legislation. And just for clarification, that's the only aspect of municipal oversight that the provincial ombudsman has. We are aware in our office of a number of reports that have been made, investigations that have happened. These reports are to be made public. That is required under the legislation. Many of them are posted online. Municipalities are not required to send them to our office or inform the ministry. It is to inform the public, so the requirement in the Act is that they be made public. As well, the ombudsman, if he is the meeting investigator, he requires that the reports be prominently posted on the municipality's website. I'm going to turn it back over to Roger.
Thanks, Jillene. It's a handful of tips for effective meetings and running effective meetings. I think that they're all fairly self-evident. In terms of not going late into the evening. No one is as fresh at 11 o'clock as they are at 7 when the meeting began. I do notice that your procedural bylaw calls for a curfew of 11 p.m. And in that same vein, my advice is not to hold off making key decisions late in the evening as well. It's just not as fresh after you've sat here for a number of hours. Allowing time for significant items to be debated and decisions to be made as well. And the last one, again, I know your procedural bylaw does contain policies with respect to the hearing of delegations. And just been in the business a long time, and there's a rural municipality up in Bruce County. It was Old Carrick Township. And George Pangdon used to be the clerk there. And this was back in the early 1980s. And he had a sign, in terms of hearing of delegations, he had a sign that was on the wall of their council chambers. And it said, public delegations, 10 minutes or 10 insults, whichever comes first. That was the painted sign he had on the wall. It's kind of cute, always remembered that. I think Jill mentioned the suite of accountability and accountability offices. I'm not going to go over those again. Just to mention that the City of Toronto is required to have these offices. For the rest of Ontario's municipalities, these accountability offices are discretionary. I think Jill mentioned what they were, so I won't repeat those. And again on the accountability and transparency theme, municipalities are required to have certain policies. So what the Municipal Act says is you must have a policy with respect to the sale and other disposition of land. What the Act doesn't say is what that policy can be. So the Act says you have to have a policy with respect to those areas, but what those policies say and what they are completely up to you. And so the policies focus on what to do. The procedures that you might develop focus on how we are going to do that. A couple of slides, switching gears a little bit. We've talked about the general principles of accountability and transparency in local government. We've talked about some of the specifics with respect to the legislation and various best practices in terms of keeping municipal business open. But I guess the good question is why? And I think the answer is you want the public to be involved. Certainly, the public can be of a significant assistance to council in generating ideas and coming up with solutions. Certainly, the engagement of your citizenry allows you to share information to confirm your decision making, to confirm the courses that you're charting for the future of your community. It allows you to explain your decisions. You can test the validity of your decisions with your electorate. Because certainly in 4 years, those same electorate are going to be, that's the ultimate scorecard on how you're doing as a council. In terms of the public relationship, again, how you conduct meetings, I think can certainly go a long way in fostering a positive and conversely a negative relationship between you as the elected council and your staff, for that matter, and your citizenry. So again, certain things to keep in mind. Again, I know you have a procedural bylaw, and it is up for consideration in terms of amendments. I guess our best advice is know your procedural bylaw, follow it, and make sure your public, your citizenry knows it as well. Some things to consider, again, timing of hearing delegations, whether delegations are up front, again, whether you require delegations to wait until later in the evening. I already mentioned we're all less effective the later a meeting goes. Again, questions about sharing agenda, sharing supporting documentation before the meeting as well. Again, and the theme of being open and transparent, the more information you're able to share with the public, I think that the better that council-public relationship will be. In terms of technology, what slide go here? Certainly, there's a lot of ways to involve your citizenry and increase their levels of engagement through technology. Certainly, the internet is certainly receiving significant attention these days. Social networking is obviously exploding in this whole arena as well. And just in terms of the internet and Adelaide Metcalfe's web presence, I was very impressed. I went to your internet. It's a very robust site. I learned about the upcoming Optimus ball tournament in Curwood, and I learned if my home alarm system goes off and it's a false alarm and the fire department responds, you're going to charge me $500. So I have a lot of information on your internet. So it's, I did some browsing on your site. But again, there's a lot of ways through the use of technology. Survey Monkey and petitions, and there's chat rooms, lots of online, lots of people are involved in blogging and tweeting. There's a significant number of new tools to keep citizenry engaged.
All right, so back to legislation. So a different piece of legislation I'm going to talk about briefly, although it is one of interest and really an important one for council members to understand and be aware of. Municipal Conflict of Interest Act. It's a short piece of legislation. If you were to print it off online, it's only about 6 pages. But there are a number of publications you can go to if you're looking for more information about this piece of legislation. One of them being a handbook on that act by Rick O'Connor, who is the city solicitor and clerk for the city of Ottawa, and George Rustai, who is an expert in municipal legislation. So I'm going to touch on who the act applies to and general responsibilities of members whom the act applies, and touch on enforcement, etc. In general, municipal conflict of interest provisions apply to members of municipal council, many local boards. Some of those local boards would be school boards, planning boards, public library boards, public police services boards, conservation authorities. In terms of the members' general responsibilities, a member must determine whether or not they have a pecuniary interest in a matter under consideration by the council or the local board. Again, it's the member I'm going to speak to here that is the person who must consider whether or not they have a pecuniary interest. It's not the clerk's responsibility, it's not the mayor or the rest of council's responsibility, it's not the municipal solicitor's responsibility, it's the member's responsibility. And if they have a question about that, they should seek their own legal advice from their own solicitor. If there is a pecuniary interest, is it one that needs to be disclosed? That's something that the member would need to consider. Not all pecuniary interests need to be disclosed. I'll touch on that a bit more later. When disclosing a pecuniary interest at a meeting, do so as required by the legislation, which requires disclosure of the interest prior to any consideration of the matter. And if it's at a closed meeting, the act requires that the member be required to disclose and then leave the meeting. Some of the other basic duties that are provided for by the legislation include that the member not participate in the discussion at a meeting with respect of a matter where they have a pecuniary interest. They also must not vote on the matter, and they cannot attempt to influence the voting on the matter before, during, or after the meeting. And again, forthwith leaving the meeting if the meeting is close to the public and that matter is under consideration. And I've said the word pecuniary interest a number of times. Just to be clear, pecuniary relates to money. It's about or pertaining to money. A direct pecuniary interest may have the effect of having the council member either gain or lose financially, and an indirect pecuniary interest of a member as a result of a relationship with another person who has a pecuniary interest. So there are also direct and indirect interests of designated family members to consider. The Act deems direct or indirect interests of certain family members to be the pecuniary interest of a member. These interests may include those of a member's parents, spouse, or children. So you would have an indirect pecuniary interest if you are a shareholder or have a controlling interest or something similar to a corporation. You are a member of a body that has a pecuniary interest, such as a service club. You are a partner of a person with a pecuniary interest, or if your employer has a pecuniary interest. And as I mentioned earlier, there are certain examples of pecuniary interests that do not require a disclosure, and you can look at sections 4 and 5 of the Municipal Conflict of Interest Act for clarification on those. But just as an example, a member may not have to disclose a pecuniary interest if, as a user or receiver of a certain public utility or another service, that generally if it's supplied on common terms with persons who are not members of council or a local board, or by reason of a member being eligible for election or appointment to fill a vacancy, office, or position in a council or a local board, or because the interest is in common with electors generally. So again, reference the legislation if you've got questions about when you would not have to disclose. When a member does declare a conflict, the clerk of the municipality or the secretary of the committee or the local board must record every member's declaration of interest and the general nature of it in the minutes. And in the event of a closed meeting, the declaration of interest, but not the general nature of the interest, that is to be recorded in the meeting of the next meeting that is open in the public. Enforcement of the Municipal Conflict of Interest Act. That is the responsibility of electors. A contravention of the Act can only be determined by a judge of the Superior Court of Justice. And an application would need to be made within 6 weeks of an elector becoming aware of an alleged contravention, or within 6 years of the alleged contravention. And the elector may be responsible for their own costs in the proceedings, or the elector, as a consequence of the decision, they may be reimbursed for their costs, or made responsible for the members' costs. If a judge does determine that there is a contravention to the legislation, they may declare the member's seat vacant. They could disqualify the member from holding office for a period of up to 7 years. They could require that the member make restitution. They may also decide not to impose any penalties for such as the declaration of vacancy or disqualification or contravention, because they may see it as the member's inadvertence or an error in judgment. So we'll reference a couple of solicitors here who have some expertise, and one of them has described the Municipal Conflict of Interest Act as the legislation that addresses a clash between private interest and public duties. He also stressed that if a councillor is not certain that the councillor must seek independent legal advice, not staff or the municipal solicitor. He also suggested that based on a recent court case, that even though the legislation does not require a member to leave the room when declaring a conflict in an open meeting, it's the best practice to leave the room. A nodding head could be interpreted as attempting to influence council. And as you may know, there was an inquiry in Mississauga In November 2009, the City Council adopted a resolution to appoint a judge to conduct an inquiry, and the inquiry looked at two broad areas, issues around their hydro shareholders agreement and acquisitions of land by the City of Mississauga. And Justice Cunningham released his report in October 2011, made a number of recommendations, including recommendations about Municipal Conflict of Interest Act as well as the Municipal Act with regards to a code of conduct and integrity commissioners. Some of the recommendations that he noted sought to bring greater clarity to the Municipal Conflict of Interest Act and asked or suggested that there be a broader range of penalties available to the courts, add a preamble to the act that sets out the broad overarching principles, also suggested allowing integrity commissioners to investigate matters under the Municipal Conflict of Interest Act. And then, as I mentioned, he made recommendations to broaden the scope of the act to cover siblings and other relatives of members, to apply private interests, to apply any meetings attended by members in their official capacity, and allow others, municipalities and organizations, to bring applications under the act. So those recommendations could be considered by the Minister of Municipal Affairs and Housing. There's always opportunity for a review of the legislation under our ministry. That is the end of the presentation. We've pretty much done that in an hour, and if there are any questions, we can take them through you, Your Worship.
Are there any questions from council for Julie? Thank you very much, Jill and Roger and Sandra, for your presentation.
I'm sorry, David, I was trying to go back through
Okay,
my
sure.
notes, but just a question to Jill in regards to the recording of the minutes and that. And as you were here earlier on in the evening, Councillor Smith had asked for some amendments to the meeting as being some of the wording left out. Could you explain to us what the clerk's responsibility is in regards to minute taking and the recording of motions and decisions?
The Act does speak briefly to that and states that the minutes are to be recorded without note or comment. That's all that the legislation says. There are probably best practices you can find on your municipal associations and so the staff would attend associations such as AMCTO, or even looking at some of those leaders in the fields that write on accountability and transparency in local governments, and possibly looking at other cities' practices with regards to minutes. It's without note or comment in terms of what the legislation says, and that's it.
Well, thank you. Would you like a minute to back up your
You're right. Thank you very much.
Maybe while they're doing that, we have a delegation of Jeff Matthews, Craig Sari, and Reg Hartford. If they'd like to move forward and get their presentation here.